My name is Daniel Barker. I'm Chapter Labor Counsel for ABC of Wisconsin, and I'm a lawyer with the Madison office of the Jackson Lewis Law Firm. Today, I'd like to call your attention to a critical update from the National Labor Relations Board's General Counsel that directly impacts many construction employers regarding stay or pay agreements, particularly those involving apprentices. On October 7, 2024, the Labor Board's General Counsel issued a memorandum addressing the stay or pay agreements. The most common of these agreements are training repayment agreements, where employees may have to pay back some of their training costs if they leave employment within a specified time frame. This is relevant for ABC members who might have agreements with apprentices that mandate repayment of tuition if the apprentice quits early. The NLRB's General Counsel took the position that many of these agreements are illegal restrictions on employee labor law rights. Among other things, she's claiming that these agreements restrict employees' protected rights to resign from employment as a group. In her memo, the General Counsel says that training agreements must only relate to voluntary training, cannot apply to mandatory training. She also says that employers may not force agreement as a condition of employment and that any repayment terms must be reasonable. Lastly, the memo states that employees should not be required to repay if they're terminated without cause. In all practicality, her memo is extremely complicated, perhaps intentionally so, to cause employers to simply throw up their hands and conclude that it's too hard to comply with these, so they don't even try to use these agreements anymore. The General Counsel ended her 17-page legal memo with a warning. She gave employers 60 days to fix any non-compliant agreements and said that after those 60 days were up, she would prosecute employers who didn't toe her line. She said that she planned to seek creative remedies, such as seeking extra money that an employee could have earned elsewhere if they were not dissuaded from applying at a different employer due to a repayment agreement. For example, she might claim that a non-union employee is entitled to wages at union scale. The practical effect of this is that employers who use a repayment agreement and don't rescind it within a 60-day period are risking a complaint and expensive or uncertain litigation with the NLRB. It's important to note, while that the General Counsel's memo is not binding on the board, the General Counsel is the prosecutorial arm of the Labor Board, and no one can predict how the Labor Board or the courts may rule on this new legal theory. This brings me back to a long-standing theme. The one thing that the NLRB will never be able to legislate away from the merit shop is its ability to create a nurturing environment for apprentices, where they are valued for their work and are viewed as a key part of the team, a place where they can grow based on their own merit. That basic appreciation, and not any repayment agreement, that convinces employees to stick around for the long haul.